Imagine you've poured everything into a big project. The work is done, the invoice is sent, and you're expecting payment. Then, instead of a wire transfer, you hit, well, just a wall of legal arguments. What happens next?
Yeah, it's a scenario far too common in the construction world, and it's precisely what we're taking a deep dive into today. You're going to learn how UK courts really protect those quick payment mechanisms, why the precise details of a contract matter so much, and how these seemingly small legal points can have surprisingly big consequences.
So our mission today is to cut through the legal jargon, really, and pull out the key takeaways from the battles fought by Lapp Industries and First Formations. We're focusing on two big questions, aren't we?
That's right. First, was there one overarching contract or many separate ones? And second, crucially, did the initial adjudicator actually make a fair decision? We want to show you why this case is such a vital reminder of how construction contracts and disputes get handled here in the UK.
Okay, let's get into it, starting right at the beginning. The project itself, we've got Lapp Industries Ltd, the claimant, and they were engaged by First Formations Ltd, the defendant. This was back in 2022 for refurbishment work at 7175 Shilton Street in London. What kind of project was this initially, and were there any sort of red flags right from the start?
Well, initially it looked pretty standard, actually. Roof, decking, reception areas. Lapp sent a quote for that on June 21st, 2022.
Okay.
And Formations accepted it just a week later. Those specific works, they were done, invoiced, and crucially, paid without any fuss.
So the problem wasn't the start.
No, not really. It was how the project evolved. That's where things got complicated.
Right, that sounds familiar in construction, so it wasn't just a one-off job then.
Not at all. As often happens, the scope just ballooned. It grew to include demolition on the second and third floors, they called it upper floors enabling works, and a whole load of other bits and pieces. Lapp ended up submitting something like 14 further quotations for approval over time.
14. Okay. Fast forward to April 14th, 2023. Lapp sends an application for an interim payment, £120,000, including VAT. The application goes out. And then what? What's the sort of key legal bit here that turns this into the main dispute?
This is where the UK's specific construction payment laws really kick in. Formations, they did not issue a valid payment notice or a pay less notice in response to Lapp's application.
Okay, and that's critical, isn't it?
Absolutely critical, because under the contract terms, if they fail to do that, Lapp's application automatically becomes the default payment notice.
Wait, hang on. So if they just don't respond properly, the original application becomes the legally binding notice. How does that work?
Exactly. It's basically a protective measure for contractors. If the paying party misses the deadlines for their own notices, the payee's application stands as the amount due. It's designed specifically to keep cash flowing in the industry.
Got it. So legally, Lapp was entitled to that £120,000.
Correct. But Formations didn't pay up.
Right. So payment wasn't made. Lapp then, understandably, starts adjudication proceedings. That was November 22, 2024. Mrs. Grace Chang was appointed adjudicator. What was Formations' immediate reaction?
Straight out of the gate, they raised a jurisdictional challenge.
The jurisdiction argument first.
Yep. Their line was, look, there wasn't just one contract here. There were loads of them, numerous contracts. And therefore, they argued, the adjudicator didn't have the authority, the jurisdiction, to decide a dispute that supposedly covered multiple agreements.
That's quite a common tactic, trying to knock the adjudicator out before they even start properly. How did the adjudicator, Mrs. Chang, rule on that point?
Well, on December 12, 2024, she made a key preliminary ruling. She decided that, yes, there was only one construction contract between them.
Okay, so she rejected that initial challenge, but Formations didn't just accept that, did they?
No. They submitted their response to the substance of the claim, but they made sure to say it was without prejudice to this jurisdictional objection. So they kept that argument alive. In their response, they basically argued that the £120,000 payment application itself was invalid anyway for other reasons.
And then just before Christmas, December 24th, 2024, the adjudicator issues her main decision.
And she awarded Lapp the full £120,000 plus interest. But Formations still didn't pay.
Right. So Lapp had the adjudicator's decision, but no money. The next logical step, the High Court. They applied for summary judgment.
Which, for listeners, is essentially asking the court to enforce the adjudicator's decision quickly, without a full trial, because there's no real defense to the claim.
Exactly. But Formations resisted this. They brought their two main arguments back to the High Court. That same jurisdictional challenge, the multiple contracts thing, and secondly, a claim of breach of natural justice.
And just to clarify, That breach of natural justice claim means they were arguing the adjudicator hadn't acted fairly, that the process itself was flawed, basically.
Precisely. Okay, let's dive into that core jurisdictional battle first. The whole one contract or many argument. Formations was really digging their heels in, weren't they? Saying each quotation was a new, separate deal.
They were. Their argument was if there are multiple contracts, the adjudicator couldn't possibly rule on what they saw as, multiple disputes bundled into one adjudication.
But the High Court didn't buy it. It sided with Lapp. How did Lapp make their case effectively?
Well, Lapp's director, Mr. Harris, he described that initial small quote back in June 2022, which everyone agreed was a contract. Then he talked about tours of the building, requests for additional works throughout the property. He specifically mentioned that Formations never definitively finalized a specification, and things were frequently altered. It painted a picture of, well, an evolving project.
And what's really interesting, you pointed this out earlier, is that Formation's own managing director, Mr. Donnelly, he didn't actually dispute this overall picture in his witness statement.
Exactly. That's quite telling, isn't it? Even Formation's own evidence kind of supported Lapp's narrative of this fluid single project that just grew over time.
So the court looked at the facts. Initial quote accepted, clearly a contract. Then more quotes accepted, work done, invoices paid.
Right. And the court applied those standard principles of contractual interpretation. They mentioned Lord Hoffman's famous summary in the Investors' Compensation Scheme case. It's not just about the documents in isolation.
It's about what a reasonable person, knowing all the background, would think the parties actually agreed to, isn't it? Even if it wasn't perfectly documented at every single stage.
Precisely. It's about the commercial reality. And applying that, the court concluded the parties had agreed to expand the scope of the construction contract formed in June 2022 through a series of further accepted quotations.
So one contract that just got bigger, the court actually called any other analysis contrived and unrealistic for business people. That feels quite strong, quite pragmatic.
It does. The judge gave several strong reasons. He said, look, any other view is just not how business works. It's contrived.
What else supported this single contract view?
Well, all the work happened at one place, the single site. That points towards one project. Also, Lapp consistently used the same subject line in their emails for all the quotes related to this property. Small detail, maybe, but it suggests a unified view.
And the payments? Did they look like separate deals?
No, quite the opposite, actually. Formations had made advance payments, and they'd paid invoices that didn't neatly line up with individual quotations. Sometimes they paid lump sums covering different bits of work, or payments on account for the whole thing. That suggested a single ongoing financial arrangement.
And the sheer number 14 quotes.
Yeah, the judge basically said, really, 14 separate contracts, that would be surprising. He felt a reasonable person wouldn't expect Lapp to have to launch, 14 different adjudications if there was a payment problem.
It just doesn't make practical sense.
Exactly. He said this whole scenario, start small, gradually expand, ad hoc. It's not unfamiliar in the construction industry and makes far more commercial sense.
Did Formations have any decent counter-arguments?
They tried. They argued Lapp hadn't properly pleaded a single contract in their legal documents, but the court kind of batted that away, saying the real question was whether Formations could show multiple contracts, and they couldn't.
What about differences in term between quotes?
They pointed to minor differences, like payment terms. The court said, yeah, minor differences, but they don't undermine the big picture of one expanding agreement.
And the evolving scope.
Formations argued the way the scope changed wasn't consistent with one big contract. The court just said, no, it was quite consistent with a single contract gradually being expanded. Pretty straightforward dismissal.
They also tried a sort of last-ditch argument, didn't they, saying maybe some conversations or conduct might come out at a full trial.
Yeah, but the court called that surmise, basically speculation. Formations couldn't point to anything specific, so the court wasn't interested.
Okay, so the single contract argument holds. Now, this raises that interesting point about whether the adjudicator could even decide this in the first place, the jurisdiction point. What's the legal position on that? Can an adjudicator rule on their own right to rule?
Yes, they often can and have to. The court relied on established cases here, like Veritas v. Mullally. The principle, often called the overlap doctrine, is that if deciding the main issue, the substance of the dispute necessarily involves deciding a jurisdictional point, like whether there's one contract or many.
Then deciding that jurisdictional point is part of their job.
Exactly. It's inherent in the task. The judge here said that deciding if Lapp's payment application was valid necessarily contained within it a binding decision on jurisdiction.
So you can't easily separate the two, even if, hypothetically, the adjudicator got the contract question wrong in law or fact.
It doesn't mean they didn't have the jurisdiction to decide it in the first place. It's often where substance and jurisdiction overlap, as the courts say. You can't use disagreement with the answer to argue they shouldn't have been allowed to ask the question.
Makes sense. So the High Court completely shut down the jurisdiction argument. That leaves Formation's second challenge, the breach of natural justice claim, the idea that the adjudicator acted unfairly.
And the court started its analysis here by, well, acknowledging how tough the adjudicator's job is. They work under huge pressure, resolving complex stuff at breakneck speed. Their decisions are only meant to be temporarily binding.
They're not meant to be perfect Supreme Court judgments, are they?
Not at all.
Yeah.
And that context is important. It leads to the principle that courts are generally very reluctant to interfere.
Right. You mentioned the Carillion case earlier. The Court of Appeal basically said courts should only interfere in rare circumstances. The default is you lost the adjudication, you pay up now, and if you still disagree, you can argue about it later in full court proceedings.
Precisely. They warned it's too easy for a losing party to just comb through the adjudicator's reasons, looking for tiny points to challenge.
Okay, so with that high bar set, what was Formation's first specific complaint about natural justice? They said the adjudicator went on a frolic of her own.
Yes, basically arguing she decided the payment application was valid for reasons nobody had actually argued.
Did the High Court agree with that?
Not at all. The court said, look, her job was to decide if the application was valid. The specific point for Formations complained about an observation the adjudicator made about previous requests for advance payments.
Yeah.
Well, the irony was that observation flowed from the material which Formations had put before her as an exhibit to the response.
Oh, seriously? So they complained about something arising from their own evidence?
Pretty much. You can't really complain about the adjudicator considering evidence you yourself submitted. The judge said this was very far from going off on a frolic. It was just a minor supporting point anyway, not even central to her final conclusion.
Right, okay. What was their second natural justice complaint, that key defenses were ignored?
Yes, they flagged up two specific defenses they felt the adjudicator hadn't properly dealt with.
Which were?
First, the scheme defense. The argument that Lapp's payment application didn't comply with the statutory scheme for construction contracts, those default rules that apply if the contract is silent on certain things.
Did the adjudicator ignore that?
The High Court looked at her decision and said, no, she did carefully note these points. She reached an overall view on the validity of the application, having considered them. Formations might not like her conclusion, but that's not a breach of natural justice. She engaged with the argument.
Okay. And the second defense, allegedly ignored.
The withdrawal issue. This was Formation's argument that Lapp's original £120,000 application had been effectively withdrawn or superseded when Lapp later issued a different, much larger invoice for over £426,000, which explicitly included that initial £120,000 amount.
So the argument was you can't claim the 120K separately because you've already wrapped it into a later, bigger claim.
Essentially, yes. But again, the High Court found the adjudicator had considered this. She carefully noted the points, treated it as a combined issue of implied withdrawal, estoppel, or waiver, and ultimately rejected it.
So maybe she didn't use the exact word withdrawal much, but she dealt with the substance of the argument.
That's exactly what the High Court found. She addressed the core issue.
And the court stressed that key test for natural justice challenges, didn't it? The failure has to be deliberate and material.
Absolutely. Deliberate meaning the adjudicator intentionally ignored something, and material meaning it had to be significant enough that it could have actually changed the outcome.
And here,
the court found nothing to suggest any deliberate failure at all. And even if there had been some minor oversight, which the judge didn't think there was, it was not material to the outcome. The adjudicator clearly had a firm overall conclusion that the application was valid and hadn't been withdrawn.
So it comes back to that Carillion point again. This looked like a classic case of a losing party trying to pick holes after the fact.
That's exactly how the judge framed it, quoting Carillion again, just trying to avoid paying up.
So summing up the High Court's decision then.
Pretty straightforward in the end. The High Court rejected all of Formation's defenses, both the jurisdiction argument and the natural justice claims.
And the outcome for Lapp Industries.
Summary judgment granted. They get the £120,000 awarded by the adjudicator, plus her fees, plus interest, all enforced by the High Court without needing a full trial.
So Lapp gets paid, and you mentioned formations had tried another road as well.
Yes, just briefly. The court noted formations had also started separate court proceedings back in January, using something called a Part 8 claim, trying to get a declaration that Lapp's payment application was invalid. But the judge had already ruled that wasn't the right procedure for this kind of challenge, effectively shutting that door too.
Right, so a comprehensive win for Lapp in the High Court. Okay, let's pull back. What does this all mean for you, our listeners, particularly those in or dealing with the construction industry?
Well, I think this deep dive really underscores just how robust the adjudication enforcement process is in the UK. Courts will back adjudicators' decisions unless there's something seriously wrong, a clear lack of jurisdiction, or a really significant deliberate and material breach of natural justice.
It shows that the courts really do prioritize the aim of adjudication, which is quick payment, doesn't it?
It does. And it also shows that commercial reality, how things actually work on the ground, often carries more weight than trying to create overly technical legal arguments after the event.
So, key takeaway number one, that single contract versus multiple contracts debate often comes down to the practical reality of how the parties work together, not just how many pieces of paper were generated.
Exactly. And
Yeah.
key takeaway number two, while natural justice is obviously crucial, adjudicators get a fair bit of leeway because of the speed they have to work at. You can't just nitpick their reasoning afterwards and expect a court to overturn the decision. The bar is deliberately set very high.
Okay, a final thought to leave everyone with. Given how critical these payment notice rules are and how binding adjudication can be, especially when a project scope just sort of grows organically like this one did, what proactive steps could companies on the paying side, like formations here, take during a project to maybe better manage these risks? To avoid ending up in this kind of enforcement situation when contracts expand through lots of ad hoc agreements.
That's a really important question, isn't it? Maybe something about clearer variation procedures or consolidating agreements periodically. Definitely something to think about.